constitutional, the doctrine of proportionality from a constitutional angle. And then that will determine whether that remedy for conservatory orders is effective or not. Now, the first petitioner was impeached. The first petitioner was impeached on 5 major grounds. That is important for you to determine the effectiveness of the remedy and the prima facie case threshold. He was impeached on gross violation of the Constitution. On that link, there were 3 grounds which were confirmed on gross violation of the Constitution. Secondly, the first petitioner was impeached on the ground that there are serious reasons to believe he's committed crimes under national law. In this case, crimes under the National Cohesion and Integration Act. And the last ground, he was impeached on gross misconduct. Now, in determining the effectiveness of this remedy, the petitioners are arguing that you issue conservatory orders that reinstate this person to office. And our position is that you cannot issue conservatory orders that reinstate this person back to office because of the reasons why he was impeached. So you have to examine the grounds for impeachment. Secondly, what is the decision that is before court? What is the decision that is before court? Have the petitioners amended their notice of motion application to reflect the grounds which they are not happy about? Because, my Lord, we presume, my lady, that they are, of course, not complaining that the Senate dismissed some of the grounds. We presume that they are complaining about the decision of the Senate, which is agreed to. So which they are agreed to. So, my Lord, if you look at the motion, you will find particulars of matters which relate to allegations which the Senate dismissed. And they are laying that as a basis for the grant of conservatory orders. You will find dominantly material with respect to ground number 7, which the Senate dismissed. Then they are saying that is a basis for the grant of conservatory orders. And we are saying, but to that extent, they have not completed the test in terms of putting an arguable case in the court. They ought to have amended their pleadings to reflect the correct complaint which they have before court, and which they ought to lay before court. Secondly, thirdly, in determining the threshold, in determining the agreeability threshold, I just need to mention 2 decisions from the Supreme Court that you will have to consider. In determining whether they have a prima facie case, you will, of necessity, look at the decision of the Sonko, the Sonko judgment that has been famously described as the Sonko judgment. Now, this Sonko judgment contains principles when it comes to the threshold for all these 3 grounds that the Senate found to have been confirmed. So, for purpose of determining an arguable case, the petitioners have not been granular. They have not complained for purpose of laying a basis with respect to these grounds on why, for example, when it comes to the question of threshold, are they complaining that these grounds don't meet the constitutional threshold? So I invite you to look at the case of Munya as well. And lastly, on the question of the ground of conservatory orders, the Kariuki Mate decision. There is a reason why the Supreme Court did in the Justice Kariuki case, the High Court to apply the doctrine of judicial restraint in granting ex parte orders. And we are arguing that if you look at that decision again, the same reasons why the Supreme Court informed the court not to grant conservatory orders with respect to active parliamentary proceedings, those same reasons are available when you are determining the effectiveness of the remedy of conservatory orders. And it's our firm submission here that conservatory orders, if you look at the four corners of the Constitution, the provisions of Article 23, should not be granted in a manner that reinstates the impeached deputy president back to office. Because then what will be the purposes of granting that conservatory orders? He goes back to office, he's been impeached for violating national values and principles of governance. So where does the test lead to? We submit that the remedy for the grant of conservatory orders that they instead is not available to them. The reason is that conservatory orders is a highly and ineffective remedy. Conservatory orders will mean then that this court intervenes on matters which are dominantly political. And in the Munya decision, there is a finding that you cannot intervene on matters which the Supreme Court has stated are supposed to be properly before the other arms of Parliament. It is only the Senate and the National Assembly, as it were in the first instance, that can determine the question of impeachment. Impeachment is about policy, political accountability, and governance responsibility. So to that extent, I wish to submit that the petitioners have not, in terms of the effectiveness of this remedy, laid before court enough material. And I wish to stop there and ask my colleague Mutembei to complete our other part of the submission. Thank you.
My lords and my lady, my name is Michael Mutembei. I'm hearing for the 9th respondent. On our part, we rely on 2 affidavits, one sworn on the 22nd of October, a supplementary affidavit sworn on the 27th of October, and submissions and list of authorities dated 27th of October. My lords and my lady, permit me to address you on 2 critical issues. One is the issue of public interest, and the second is the legal theory of realism as to why conservatory orders cannot issue, especially as to sustain the first petitioner in office as deputy president. On the first issue of public interest, my lords and my lady, you have been told this morning by the petitioners that the office of the deputy president can remain vacant for a period of even up to 60 days because there is no function that would not take place in government. It is our submission first, my lords and my lady, that the deputy president is mandated to chair the Intergovernmental Budget and Economic Council, which is created by Article 6, subsection 2 of the Constitution and Section 187 of the Public Finance Management Act. And the Intergovernmental Budget and Economic Council coordinates government policies, legislation, and functions as between the national and county government. My lords and my lady, the law prescribes that the chair and convener of this council can only be the deputy president. There is no other person in law that can convene the Intergovernmental Budget and Economic Council. Secondly, my lords and my lady, under Article 240 of the Constitution, there is established the National Security Council. And one of the members of the National Security Council is the Deputy President. And it is our submission that pursuant to Article 240 of the Constitution, there is no other person or holder of any other office who can substitute the Deputy President as a member of the National Security Council. This is important, my lords and my lady, because the National Security Council exercises supervisory control over national security organs. This is a critical function of the state. In the absence of the Deputy President, there is legitimate reason to believe that the National Security Council is not properly constituted. And again, this is important, my lords and my lady, because if you look at Article 240, subsection 8, the Council may, with the approval of Parliament, deploy national forces outside Kenya for either regional or international peace support operations or other support operations. So that the situation subsisting as at today, my lords and my lady, is that the National Security Council cannot deploy any national forces either for support operations within the country or international peace support operations. And I urge and respectfully submit to this court to take judicial notice that officers from the National Police Service are currently deployed in Haiti to support with peace operations. So that the argument by the petitioners that the office of the Deputy President can continue to remain vacant is not available because these two critical functions provided by the Constitution and law would not effectively be carried out. On the second issue, my lords and my lady, I invite you to look at Article 3 and Article 4 of the Constitution, and particularly Article 4, subsection 2, which states that the Republic of Kenya shall be a multi-party democratic state founded on the national values and principles of governance referred to in Article 10. The words used in this section are shall, which is mandatory, and the first petitioner avers in his supplementary affidavit, and I wish to draw your attention to his supplementary affidavit in paragraph 17. That is a supplementary affidavit dated the 27th of October 2024. And on oath, he avers on paragraph 17 that I observe that in other open and democratic societies, and he goes on to say, unlike Kenya. So the first petitioner is averring on oath that Kenya is neither an open nor a democratic society. That is his own affidavit. It is our submission that conservatory orders would militate against legal realism to reinstate a person who cannot safeguard the oath he took as Deputy President, safeguard the Constitution, and who avers in open public that this country is not a democratic society. My lords and my lady, I also invite you to look at Article 130 and Article 131 of the Constitution, which provides that the head of state, the president is the head of state, and the deputy president deputizes him. And in the authority of the president as provided in Article 131, particularly subsection 2C and D, is to promote and enhance the unity of the nation and to promote respect for the diversity of the people and communities of Kenya. It is our humble submission that any grant of conservatory orders that would sustain the first petitioner in the office of Deputy President would be a violation of this article, it would also be a violation of Article 147, which provides that the Deputy President is the principal assistant to the President and shall deputize the President in execution of his functions. And why this is important is because in the supplementary affidavit dated the 27th of October, we have deponed, or the 9th respondent has deponed, and particularly in paragraph 16, several averments by the first petitioner in which he infers that the President is responsible and must be held to account if anything happens to him. And I will not indicate the rest. You will find them in the supplementary affidavit. So that, my lords and my lady, pursuant to Article 147, it is now no longer tenable that the first petitioner, either at the interlocutory stage or on the final orders of the petitioner, can continue to be the principal assistant to the President. My lords and my lady, I also draw your attention to Executive Order number 1 of 2023, which stipulates that the Deputy President shall chair cabinet committees and shall coordinate issues of budget and policy making of constitutional commissions and other independent offices. Our first submission is that as we speak, there is no person who can execute the function of chairing subcommittees, chairing cabinet committees. On the issue of constitutional commissions and independent offices, it is our humble submission that the Senate, having found the first petitioner guilty of violation of Article 160, then he cannot coordinate any functions with the judiciary effectively. The final thing, my lords and my lady, I would wish you to look at is the issue of political parties, particularly the role they have in policy formulation, political mobilization, and political democratization under Article 4 of our Constitution. The first petitioner was impeached by the Senate by a supermajority, which included members of his own political party and coalition. And I would want to draw you to a comparative analysis. When you retire, you will look at impeachment processes, which we have default to in the USA, in South Africa, and Brazil. But it will be instructive to note that closer home in South Africa, when Thabo Mbeki lost confidence of his own party, he resigned in 2008. And when Jacob Zuma lost the confidence of his own party, he resigned in 2018. So we respectfully submit, on behalf of the 9th respondent, that because of those two issues, conservatory orders cannot issue in this matter. Thank you, my lords and my lady.
Thank you. Thank you very much, my lords and my lady. I want to take 2 minutes to delve into the reasons why we support the applications to set aside the conservatory orders, and pray that the applications for those conservatory orders be dismissed. My name is George Murigara. I'm here with the team for the National Assembly of Kenya. I begin by drawing your attention to the provisions of Article 118 of the Constitution, which actually deals with the public participation, which has been debated on and argued on in the House. And what I wish to draw the attention of the court to is Article 1, paragraph B, where Parliament is mandated to facilitate public participation and involvement in the legislative and other business of Parliament and its committees. What I wish to point out here is that not all business of the National Assembly or of Parliament has to undergo a public participation, because not all legislative duties or other business actually does go through public participation. There are legislative processes in this country which need not be subjected to public participation, and also other business of the House which need not be subjected to public participation. What is important is the wording of that clause. The word "or" is not used, because if that was the intention, that everything that the Parliament does has to undergo public participation, it would have been that in all legislative and in all other business of Parliament and its committees. However, I take you to Article 145, where there was public participation, in spite of the fact that there is no provision that there ought to have been public participation when the motion was actually moved. The correct position is that any member of the National Assembly, on attaining the threshold, can actually move a motion that the President or the Deputy President be impeached. Once that motion is moved, then it goes to chamber, it is debated, and it is voted on. So it is actually for Parliament to determine when to take such a motion for public participation. And I confirm that here, out of abundant caution, Parliament did take this motion to public participation on 2 days, as was even ordered by the court. And after the public participation, there was debate on it in Parliament. It is this debate that takes into account the public participation, the views that were collected from the public out there. Then after that, a vote was taken, and therefore that process cannot be faulted. It cannot be said to have been flawed in any way, because in spite of the fact that there was no requirement for public participation, it was done out of abundant caution. Finally, there has been an argument that under Article 149, there ought to have been public participation regarding the nominee who was taken to the House for voting. And here we must draw the distinction drawn that this is not an approval. Approval on appointments comes under different articles of the Constitution. It's clearly provided that the appointment would be with approval of Parliament or approval of the National Assembly. Here, what took place was just a vote. There was no motion, because there is no requirement for a motion. There was no debate, because there was no requirement for a debate. Because what the law provides is the President nominates and the House votes. So the House sits, it's called to vote on the nominee on the basis that possibly the nominee is known to the entire country. And this is the reason why there is no public participation. If Parliament votes against that candidate, then the President would have to nominate another candidate and continue doing so within a span of 60 days, and until he gets a vote that is positive in his favor, not an approval. And we've said that approvals usually come under the Public Appointments Parliamentary Approval Act. This is the one that governs approval. This is the one which provides that there must be public participation in all public appointments when actually Parliament has to offer an approval. So finally, public participation here goes to Article number 1, where Parliament is exercising delegated powers of the sovereignty of the people of Kenya. It is presumed that when Parliament votes, the candidate is known to the people of Kenya, and through their elected representatives, they have actually to cast votes which are in tandem with how their constituencies would have voted. So with these remarks, it is my submission that the nomination and the subsequent vote in his favor of Professor Kithure Kindiki was ordered, it was actually appropriate, and it cannot be voted in any way, and therefore those conservatory orders should be removed. Thank you very much.
Distinguished members of the bench, Mahat Somani. For the record, I do appear with Dr. William Tubwa, Mr. Hassan Nura, for the IEBC, they are all here. Dr. William Tubwa and Mr. Hassan Nura. We are the 16th respondent. We are not with the other respondents. We are the IEBC. We are on our own, and to clarify matters to the court. Distinguished members of the bench, just for the record,
we hope that you are not sharing the minutes. Please 5 minutes.
The Lordship, it's just me, we are not sharing. We decided we will not distribute the time. I will try to cover as much ground as I can in the time I will take. If I need 1 or 2 minutes, it will be kind enough to but I will try to cover. I know it's very late. Just for the record, we rely on the replying affidavit sworn on the 25th of October 2024 by Hussein Marjan Hussein, who is the CEO of the Commission. We rely on the written submissions dated 27th of October 2024 in response to the various petitions and the applications. We rely also on the written submissions dated 27th October 2024 with regard to the application for conservatory orders, as well as the bundles of the authorities, they are on record, Lordship, and we have filed and served the same. Lordship, on preliminary issue, it's good I came last because it was a learning experience for me, but also for preliminary issues. To the extent that a lot of the petitioners and even some aspect of the respondent dwelt on merit review of the petition. When this is an application for conservatory orders, those submissions should be disregarded by the court. That's the first one. The second aspect, even though the decision for the petitioners is an application for their rights in persona, the fact that the IEBC is here and this is a public interest matter, your decision will be a decision in rem. So the IEBC will be asking that you clarify for it the applicable principle and guide it on first principles. The third one, and which is very important, is it seems that there's a general agreement that the law that will apply, and this is the only thing that all the lawyers agreed on, is Munya. Itagatirao Munya is the standard for conservatory orders. We believe the court should adopt that standard. I will not dwell much on the prima facie case, but I will dwell a little bit on the negatory aspect as it relates to my client. My client has been bundled up into these proceedings to establish the application for conservatory orders on 2 grounds. And this is important for the court to note this, on 2 grounds. The first one, the petitioner said that the IEBC has a constitutional role in filling a vacancy in the office of Deputy President under Article 149 of the Constitution. And this is important. The second aspect, they say that even though they have a role, they cannot discharge that role because they do not have the constitutional or legal capacity to function, as they don't have commissioners. This is very interesting. This is what my professor at Harvard Law will call, will call constitutional chaos. So they tell you there is a role to be played by the constitutional body. And then they say, once you establish there's a role to be played by the IEBC, IEBC cannot play that role. The Lordship, the Impeachment that Irao Munya, and this is a point that has not been made by most of the council, the issue of conservatory orders is not for the benefit of the private or the public party. Conservatory orders is for the benefit of the court. Because they are supposed to preserve a judicatory capacity of the court. Just that. If a party benefits because of that, that is collateral. And that is really important for this court. Because once you establish it for your adjudicatory capacity, two things fall away. The first thing that will fall away, if you find that there is a remedy, there is an alternative remedy in merit review when the petition is heard, there are remedies that subsist when the petition is heard, then that aspect falls away. The second aspect that will fall away, if you make a finding that there's a constitutional mandamus, and Your Lordship, I will refer to you to Article 145(7) of the Constitution. If you make a finding that there's a constitutional mandamus, injunction, edict, direction to the court, then you have to stop there. And Article 145(7) is in such mandatory terms that there is no other way that this court can interpret. X, the president shall cease to hold office. Constitutional injunction, mandamus. So once if those two findings are made, then there is no way the petitioners can establish the negatory aspect. As relates to the two issues, the gravamen of dispute, the position of the IEBC is that the IEBC does not play any role as relates to vacancy through impeachment under Articles 99 and 137 of the Constitution. There is no constitutional role for the IEBC. There is no statutory role for the IEBC, and I'll come to that because we spent quite a bit of time. Just like the predicament the court is in, whether it should intervene under 165, we also have that predicament. Is there a role for the IEBC? That is the question the CEO of the IEBC asked. And we came to the very considered conclusion, there is no role for us because of constitutional design. And I'll come to that constitutional design. Unlike the court, the IEBC has been involved in a lot of litigation against itself. And there is directions from the Supreme Court of the Republic on what IEBC can do and what IEBC cannot do. I want to refer the court to paragraph 13 of our submissions, the BBI case, the Supreme Court one. And IEBC here can be substituted also for this court, because this court is a creature of Chapter 10 of the Constitution. The IEBC is a creature of Chapter 15 of the Constitution. And this is what the Supreme Court says. At paragraph 13 of we've quoted it verbatim. Number one, the Supreme Court says the IEBC, being a creature of Constitution and statute, could only discharge mandate vested in it explicitly by law. This court, being a creature of the Constitution and statute, can only discharge mandate vested in it explicitly by the law and the Constitution. The second one, which is very important for this court, is the court said that this was direction given under Article 10(2) of the Constitution and the aspects of rule of law under Article 10(2). The third point that the court made, the IEBC, like other public bodies, could not by craft of innovation, and this is really important, Supreme Court. The IEBC, like other public bodies, could not by craft of innovation or interpretation extend its powers. So it is sufficient for the IEBC or even for this court to look at the Constitution, the Constitution and the statutory law and not get and exercise what is within the inner boundaries of that. And D, which is to this court, courts should not encourage extension of powers by constitutional or statutory bodies. And this is really important, paragraph 13 of our submissions, Your Lordship. So the constitution of my client IEBC is under Article 88(1), 253, and 259. The position of the IEBC relating to this matter is that Article 149, 145, 150 establish a complete self-contained code. It is a constitutional codified mechanism. It's not a statutory mechanism for governors or members of National Assembly. It is a constitutional codified mechanism. So when this court is interpreting, IEBC is a creator of the Constitution. This process is a creator of the Constitution. You cannot get out of the Constitution for this process. This court is a creator of the Constitution. So as it relates to the nomination by the President, as it relates to the parliamentary vote, it is not envisaged there is an involvement of the IEBC. This is a constitutional mandamus. As against the IEBC, and I will say as against even this court, we also rely on the case of Engineer Geoffrey Sang versus the DPP and 20 others, your brother Justice Odinga, paragraph 18 of our submissions. And he says that the law is very clear that powers must be expressly conferred. They cannot be a matter of implication. You cannot imply powers. And this is the absurdity. If this court was to make a finding, for example, that IEBC has a role, the way IEBC conducts elections is known, or by-elections. So the second order question we'll be asking the court is, do we declare by-election? Election by its nature is a contest. How will that contest of filling that office be had? Do we print ballot papers? Those are the secondary order questions that the absurdity of the finding of the court that IEBC has a role will entail. The second thing, our position, is that this constitution is very detailed. It is very interesting. This constitution tells you how it should be interpreted under Article 10. It tells you under Article 201 how the principles of taxation that will apply. It has what we call constitutional carve-outs, the powers given to various entities. It will be high presupposition to assume that this constitution under 149 could have said that this process, it says for even members of National Assembly. It says for members of National Assembly, and even in the elections that we have that. For an office that is that high, to say that the Constitution could not have said that IEBC has a role or this court has a role will be a very grand supposition. Your Lordship, we looked at, so we asked the question, what the court should ask. If someone said IEBC has a role, we looked at the things that we will look at. So we'll say, what did the framers think? Can we look at constitutional history to say if there was a role for the IEBC? The IEBC looked at the Bomas draft, Article 168. It looked at the Wako draft, Article 159(1), and we looked at the Harmonas draft. And in all of them, there is no role for the IEBC. So even by constitutional history and constitutional design, there was no role for the IEBC. In fact, there was a role in the Wako draft for the Supreme Court, and those submissions have been made by Mr. Mugomi Yantolu.
Thank you.
Your Lordship, just 1 minute, I'm almost winding up. Your Lordship, for you to, and then there's a second issue, and then the reason why the court should not interfere in this process, especially I would find there's a role for IEBC. For you to make a finding, for you that the first finding that you have to make, there is first, the people who hold public office, they hold what we call rhetoric relationship. These are relationships of trust and confidence within our constitutional architect. relationship of trust and confidence within our constitutional architecture. So you have to make a finding first. There is a property in public office, okay, number one. And that confidence is to the constitution, number one. You have to make a finding. There is a property to hold in public office, okay? Even when there is a breach of that trust, and a finding has been made by other organs of the constitution. And the court, the test has always been threefold. Number one, total interference, judicial fear. And we don't do that, our courts don't do that. We don't substitute, courts don't substitute their preferences to what other organs do. The second aspect has been total deference. Not what other organs do, but total deference to the constitution. And this is very funny. Professor Gigi Mugai is here. I used to teach first year contract, and the case of Feldhouse versus Bindi came to mind. That the constitution is silent, so that means that we can read into things, or we can tell the court to intervene. The constitution is silent on the court intervention under 149, so we will read into it. So that's the second aspect. Total deference, if there is a constitutional injunction, constitutional mandamus against a public body or against this court, then the court should be able to deal with that. The third one is the intermediate test. And this is what the court has applied, Your Lordship. The intermediate test is you do procedural constitutional compliance. This is our authorities in E181, Justice Majanja's judgment in the Finance Bill Act. In fact, the decision of the Finance Bill Act Supreme Court came down a few hours ago. I think we provide to the court should look at it. The threshold for public participation is not BAT, by the way. The threshold for public participation is even lower because of that decision. And when you look at that decision, which we provided to the court does what we call procedural constitutional compliance. And what is that? You look at whether a vote happened and the threshold within the constitution have been made. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, on that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of the, it is the, Your Lordship, just the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer them.
How is it reported?
It is reported as E031. Let me just not reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury versus Okia Omtata. I argued that matter. I was led by Professor Gigi Mugai. Mr. Ochiel Dad is there, he can revert, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic it quoted the case of International Trade Administration Commission versus in South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law. It is a direction to you. And if you look at that case, if you look at Peter Munya, if you look at the nugatory aspect, and if you look at the fact that there is at what the submissions of Marjan Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against IEBC. Because if you told me this is an election you are able to clear, then I'll tell you, how am I supposed to conduct this nomination process? And what are the constitutional orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
Oh. I was being told by Professor.
Professors on this side,
my professor is telling me to step down, but if I can, just a second.
Okay, you can step down.
But Professor, but our submissions are those ones, they are on record, and even if there is a role to be played by IEBC, our position is those are administrative roles which we will still play, but. And that is provided for under Section 11 of the IEBC Act, Section 13(1) of the IEBC Act. The role that we have to do under 137 is to check the voters register. And we check voters register for even people who, for Kenyans every other day, it's a public document. There's no role for the IEBC to play. And if the court was supposed to play, there was a role for us, then we say those are administrative roles, but the court should not find a role for us.
This supply authority you have quoted of E031 to E033 for 2024.
I will, it is hot off the press, I will submit it just now.
Submit to our assistants.
I will, Your Lordship. I will, thank you so much for this.
My Lord, I want to apologize if I appear to take the issue of discretion from you. It was intended to keep my promise to you that we would be good.
We now get to know that every side has a prefect. This side, the prefect is Professor Gibb.
My Lord, I just want to also add my voice in the submissions that have been made by the respondents. They should go on record that my name is Shaka, Solicitor General for the Attorney General, together with Professor Mutembei and Charles Mutinda and the rest of the team. Yes, my Lord, to say one or two things so that we wrap up submissions from our end. My Lord, it is not in contestation that under Article 145(7) of the Constitution, a final decision of impeachment was made. It is not in doubt, and that has not been controverted by either side.
What we have. That is what we are challenging.
A final order, at least, my Lord, was made. Secondly, my Lord, it is also not in contestation that a vacancy has arisen or arose in the office of the Deputy President. It's also, my Lord, not in contestation or in doubt that Article 149 of the Constitution was invoked in terms of the President nominating Professor Abraham Kithure Kindiki as a nominee to that position, and that Parliament voted on the same. And I would agree with my learned colleague who has just left the floor, Mahat, that the framers of this Constitution never intended that the IEBC plays a role when it comes to the issue of impeachment. And my Lord, if they so intended, nothing could have stopped them from expressly stating that position. And therefore, my Lord, I am submitting the interim orders that were granted and are in place cannot cure that position. And therefore, my Lord, relying on the various authorities that have been cited, and more particularly, my Lord, the Munya case, which is a classic case in terms of what will be required in the grant of conservatory orders. It is my humble submission, my Lord, that that has not been met. I also submit, my Lord, that when you look at the greater public interest, my Lord, we want to persuade you with the very many other arguments that have been given by my learned colleagues, that you will find favor that the discharge, the vacating, or the varying the orders that have been in place would find greater good than holding those orders in place. And therefore, my Lord, to conclude, I would urge my lady and my lords to find that we cannot continue holding the country at ransom. We need to make a decision that some of the roles and the responsibilities that are played by the deputy president, which are currently at a standstill, would be extremely good and critical that the moment these orders are vacated, the rest of the processes should be allowed to be completed. I therefore humbly submit that you discharge the orders that are in place and allow the entire process to be completed. I submit, my Lord.
Thank you. My Lord, I want to confirm on behalf of the respondents that we rest there, that with your kind indulgence, if there is to be a reply, I think again we need to remind ourselves that it ought to be on points of law. If the case is rehashed afresh, we would still be here tomorrow and it would contrary to procedure.
My Lord, I also request a direction on whether persons who are not parties to the application, because there are only 2 applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Okay.
Why are we being preempted?
Moving forward, I think we still have to hear interested parties, or we have done. Yes, now the right to rejoinder is only limited to the applicants and not any other person supporting the application. So it will go only to the applicants. And in this case, we have 2, and we will have how much limit?
You had given us 30 minutes. I am addressing the court case. Reply to the court. You have given us 30 minutes.
Do we do 15 or 20?
No, my Lord, there is a lot that has been canvassed. In fact, they have given us the impression that they will need less than an hour. They have obviously done 4 hours and something. We were the worst things that we want. We can do within 30 minutes. Or less, depending on how much he's able to cover. The only issue, my Lord, that is the mischief is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business and we go.
Okay, this is the way forward. We will give the respondents the time they need, 30 minutes each. Not the respondent, but the applicant, 30, let's go.
My Lord, may I please the court?
Yes, on what issue?
On the same issue, because I've been standing and I did cut your eye. Still on the issue of the right to reply. My lords, you might remember that I am, first of all, I am one of the unrepresented petitioners in petition 11. And for the my lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications will be had.
Now, Mr. Bosho, just a minute. We will restrict ourselves to the applications at hand. So if yours is not among the 2 applications, then you will have to address that later. And the rejoinder should be on points of law. Rejoinder should be on points of law.
My lord, I stand guided, but I still wish to point out that there are very specific issues that I raised that were not raised by the other applicants, and which the other side has responded to, and would leave the issues unresponded to altogether.
You can pass those submissions to the council for the other applicants.
My lord, before our council proceeds, I am Mwangi Munga, counsel for the 43rd petitioner, Mr. Morara Omoke, and we also had an application which we believe we have a right to rejoinder, a brief rejoinder, and it was one of the applications that was canvassed. So we also have a brief right to rejoinder. Will only take 5 minutes.
My Lord, Morara appeared in person and argued his own case.
And I am his counsel.
No.
We are here together with him.
Let us give directions and we will proceed with these directions which my Lord Judge very much so to give. There must be order in every proceeding.
Who is starting? Is it Mr. Yes, proceed.
My Lord, my name is Ochiel, and it's a great privilege and honor for me to appear before you and to make the Deputy President's rejoinder. Ochiel Dudley is my name. Lord, allow me to begin with where my very good friend Mr. Somani stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court has said this afternoon, that the framers of the Constitution made it possible for litigants, like our client, the Deputy President, without exception, to appoint the courts for redress of fundamental rights and on issues concerning interpretation of the Constitution to determine whether any law or anything said to be done under the authority of the Constitution is constitutional. Paragraph 210, Supreme Court, this afternoon, the court says that this constitutional inquiry, the inquiry we're involved in, extends, the court, when conducting this inquiry, should bear in mind the unlimited reliefs contemplated under Article 23. Not that's sufficient to clear any doubts about your jurisdiction and to clear any doubts about your power to give conservatory orders. If there are any doubts, the court should now feel comfortable My Lord, during the break, I inquired for my learned friend, Mr. Tiankolo, a very good friend of mine, and I asked him, Dr. Tiankolo, who is the governor of Meru County? He told me, Kawira Mwangaza. Then I asked him, by what authority?
Is he still submitting on points of law, my Lord?
Yes.
He went to there.
By what authority? He told me, by a conservatory order. And so, my Lord, this court can give conservatory orders against impeachment. The conservatory order we are speaking about, the one I was speaking to my colleague about, was given to this court not so far ago, on the 21st of August 2024, in petition P429 of 2024. Let me come to the other case, the Kisii governor's case. And Lord Justice Ogola, you are familiar with that case, you're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place, and that that matter would come before Justice Okoye, which is the decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. My Lord, that case is different from this one on the issue of delay. Under Section 32 of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Moratura do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Moya on 14th of March 2024. So she was coming to court outside the 14 days. My Lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My Lord, if you look at page 233 of the CKRC final report, you find Kenyans speaking about, my Lord, the need to allow the transitional processes to be disputed. My Lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court like we have. And so, my Lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kirera conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. And allow me to concur fully with two things that my learned friends, Mr. Nyamodi and my good friend, Mr. Somani, said, that conservatory orders are easy for the court because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved here is an impeachment, both of the National Assembly and the Senate, and the subsequent nomination of Kithure Kindiki to the office of Deputy Governor. And again, unlike Mora, he is yet to take oath here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petition more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders act as tools for preservation of the subject matter, hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Wendy Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kithure Kindiki is sworn into office. Other cases we agree with, cited by the National Assembly's Kitale Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. A particular state of affairs, which so far you preserved, is that our client is a deputy president of the Republic of Kenya. We ask you to sustain the conservatory orders. My Lord, County Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court would remain to the end of the term, it would remain unfilled. That time, we had not yet amended Section 32, Capital B of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable. I reiterate that the timeline we have here is 74 days. We're yet to eat into a quarter of those days, my Lord. And from the posture taken by this court, it's possible to hear this case and conclude it within those 74 days. My Lord, this petition, within those 74 days. All the three chains of Kenyans court, when required, have risen to the occasion. BBI did not last the 5 years my friend Mr. Diankoli spoke about. It lasted a matter of months. And so it's possible for this court to hold things in place and to expedite the main petition. My Lord, unless that happens, my becoming friend, Professor Gideon Migai, spoke about the dissipation of the subject matter. He said this has already dissipated. My friend, Professor Rejoinder, said